Order, and welcome to this evidence session for the Justice Select Committee, meeting for once on a Wednesday morning in order to hear evidence from the Attorney General and the Solicitor General. So we're very pleased to have Lord Hermer and Lucy Rigby MP before us. Thank you very much for attending. We will just briefly, as we always do at the beginning of the committee, do our declarations of interest. So we'll start with Josh Babarunde.
Yeah, I'm Josh Babarunde, Lib Dem MP for Eastbourne, sunniest town in the UK. I have no other interest to declare aside from what's in the register.
I'm Neil Shastri-Hurst. I'm a practicing barrister. I'm registered with the Bar Council and the BSB, and I'm an associate tenant at number 5 Chambers.
I'm Andy Thrall. I'm the chair of the committee. I'm a non-practicing barrister. I'm a patron of the two justice-related charities. One is Hampson from Law Centre and one is the Upper Room for Ex-Offenders. I'm a member of the GMB and Unite Trade Unions.
Good morning, I'm Alex Burrows-Curtis. I hold a practicing certificate from the SRA. I'm a member of Unite and GMB, and I'm an ordinary member of the whistleblowing APPG.
Sarah Russell. I am a solicitor holding a practicing certificate, although not currently doing any work. Apart from the much work that we're all doing as MPs, I am a member of Community and Usdaw trade unions, and I'm on the executive of the Fabians.
I'm Lindsay Farnsworth, the Member of Parliament for Amber Valley. My interests are as per the register, but of relevance to today's hearing. I'm a non-practicing solicitor, formerly of the Crown Prosecution Service, a member of various unions, including the FDA, and I'm the National Mission Delivery Champion for the Safer Streets mission.
I'm Pam Cox, and my interests are as declared on the register.
Hello, I'm Warren DeJust MP in Wolverhampton West. I'm a solicitor with a practicing certificate but not practicing. I'm an executive council member of the GMB Trade Union, and I'm a member of various APPGs.
Thank you very much. Did you want to introduce yourself?
I'm Richard Hermer. I am the Attorney General of England and Wales and the Advocate General of Northern Ireland.
And I'm Lucy Rigby MP. I'm the Solicitor General.
Well, thank you very much, and again, welcome. And if we started with just a few very general questions, and I mean, in some cases it will be obvious to whom we're asking them, but obviously I leave it entirely up to you whether either or both of you choose to answer. The first question, which is really for you, Lord Hermer, is we note, not my research, but research done for us, that you're the first Attorney General for over a century who does not have previous parliamentary or political experience. I don't know whether you think that's an advantage or a disadvantage or it's irrelevant, but how do you see your role, given that law officers are often in that difficult position between legal advisors and having a political role?
I think there may be some disadvantages, but I think they are outweighed by the advantages. So I see my primary role as providing independent legal advice to government. I think coming unburdened by party politics at the retail end assists in providing clear and independent advice. I come with a knowledge of politics. I come with a deep interest in politics. I come with a deep interest in Parliament and how Parliament works and an understanding of how Parliament works. I don't have a lived experience of day-to-day parliamentary life, but I don't think that gets in the way of my job.
But you are now a party politician. You take a party whip in that way, and that's not something you're used to doing before. But I suppose that is no different from any previous Attorney General. But how do you manage that? I mean, your whole life experience is as a lawyer and in speaking up for your clients and in taking a position as dictated by what your brief would be, and now you've got to balance that with a slavish loyalty to parties. Yeah.
Well, there are different aspects to the role of Attorney General and Solicitor General. As I said, a kind of a really core part of that role is providing legal advice. And there is an enormous divide between my role as a politician, when I'm voting in the House of Lords, and my role as Attorney General when I'm advising on matters of law. And when I'm advising on matters of law, I am not taking a party line. I am not following instructions. I am not being party political. I'm acting purely as a lawyer to identify what the law is and how it needs to apply.
And the other thing that they said about you, perhaps again unfairly, is that you're very much a personal appointment by the Prime Minister. You know, obviously on merit, but also because he's someone who you've known for a long time and knows about your. Does that in any way influence the way that you work?
It has no bearing at all on how I work. I mean, as you say, it has a bearing on why I was appointed. But at all levels, when it comes to legal advice, whether I'm advising the Prime Minister or whether I'm advising other members of government, my personal relations with individuals has no bearing on the legal advice that I give, nor should it.
Perhaps I could ask you, you're relatively new into the role. How are you finding the role and how are you adjusting to that dichotomy really between, perhaps you have slightly more experience in party politics than the Attorney General has, but how do you see that perhaps difficult role to perform?
I think, the first thing, of course, Chair, is that it's an incredible privilege to serve this country in the role of Solicitor General. You're right, I do have some experience of parliamentary politics, but as the Attorney General says, the most important thing is the quality of our legal advice, which is delivered to ministers in a robust and accurate way. It's without fear or favour. It has a political context, but the key point is that high quality advice, and that is, as I said, with the political context, but it is without party politics.
You've spoken up very clearly. Attended your lecture hosted by the Bingham Centre on rule of law earlier, and have put the rule of law at the centre of what you say that you should do, which is exactly right in that way. What we perhaps may find frustrating is that you may state these things as a matter of principle, and we may all agree with that, but when it comes to the practicality, how it's implemented, then you would say, I'm sure, that your advice is confidential, and indeed whether you've given advice is confidential. So how are we supposed to join up the dots between, if you like, the principles that you're following and the practical effects of that on government? Yeah. Because if we ask you, you'll say not something I can discuss, and if we ask ministers about it, who may or may not be advising, they'll say, well, that's a matter for the law officers.
I think that's a really good question. Can I just firstly describe why it is I can't and Lucy can't talk about advice we may or may not have given. So as you'll all know, there's something called the Law Officers Convention, and that's incorporated into the Ministerial Code, and it means that nobody can say whether or not a law officer has advised, let alone what that advice might be. And that effectively provides the same legal privilege protection to an attorney and government as any layperson would have with their lawyer. It's a form of legal professional privilege. And I think that's an important principle to apply, because we must feel as law officers that we are able to impart confidential advice to our clients. It's essential for the good running of government. It's essential for our discharge of our duties. So I understand, Chair, that there's some frustration, not least from the perspective of this select committee, in not being able to look under the bonnet and assess, are we doing our job? Are we actually providing accurate advice to government? I think that can be tested in a number of ways, not least when we look at what government policies are and whether those government policies themselves abide by rule of law and constitutional principles. We can look at it when courts examine government policies and legislation. So there are yardsticks and there are means of assessing and inferring whether we are discharging our functions. But our functions both as Attorney General and Solicitor General in respect of the rule of law, are not limited to the confidential advice that we give to government. We play a role across government that is broader than that. So, for example, we are deeply involved in the PBL and the standards of legislation. And one of the concerns that we have had coming into government is to raise standards in how we legislate, not least in respect of secondary legislation. And that is a rule of law issue. And also, together with the Lord Chancellor domestically and the Foreign Secretary internationally, we have a role getting out there and talking about the rule of law and the importance of the rule of law. So you're right, in respect of the actual legal advice we give, the room for scrutiny of that advice is limited, but I think justified. But there are plenty of other areas of our work in which you're going to be able to assess whether or not our deeds match our rhetoric.
Yes, indeed. We might well come on to some worked examples later, perhaps. But so that's when if you like, the norm would be advice is given, advice is perhaps accepted. What happens if advice isn't accepted? Where does that leave you? If you've given advice to ministers and they've not followed it, what happens then?
Well, I mean, it's quite hard to answer that question in the abstract because it depends upon the terms of the advice. It may be, advice could be you've got a range of options. My recommendation would be A, but the minister decides to do B. Well, that's perfectly appropriate for a minister to make those decisions. It may be of a matter of little legal significance, in which a minister may take a different view to a law officer, in which law is only of peripheral relevance. There have been over history, of course, some huge constitutional issues about legality, in which law officers have had to make some very difficult decisions and give some very difficult advice. I anticipate that any government that seeks to abide by the rule of law will, when it comes to an issue of enormous constitutional importance where the law is clear, will follow legal advice.
Yeah, I mean, difficulty with examples is that you'll probably say, well, I can't really talk about that. I mean, one recent example, and I don't want to preempt questions that are coming up, but would be, say, over arms export licenses to Israel during the current conflicts arising from that. And it was thought that you had taken a legal position on that in terms of the way that should be dealt with, and effectively were saying to Department of Business or Foreign Office that this is the way you need to deal with this in that way. Is that what you see as how you can direct the way that government behaves, and then what do you do if they do not behave in the way that you expect?
Well, I can't obviously give any answer that reflects whether on a particular given issue I have given advice, let alone what that advice is, for the reasons I just explained. I accept that can be frustrating sometimes, but it's an important principle. It's also important to stress that it's not a question of law officers directing ministers to take route A or route B. It's a question of law officers and lawyers throughout government explaining to our colleagues what the law is, what the legal risks are. There may be some scenarios in which the issue is pretty clear. There's route A is lawful, route B is unlawful. And it's about providing that advice so that ministers can comply with their obligations under the ministerial code and comply with the law.
The other area where sort of deviation from the norm might happen is the general rule would be that you wouldn't publish advice or indeed indicate whether you'd given advice on a particular subject. But in some cases, advice has been published around issues such as the Iraq War, around Brexit and so forth. So, I mean, when do you... is there any guidance as to when you might publish, or is it simply on a case-by-case basis?
Well, thus far it's been on a case-by-case basis. I mean, from recollection on Brexit, that was at the will of the House. 2003, there were other considerations at play. It is obviously exceptional for that to happen. I mean, I think those are the only certainly the only two instances I can recall in modern times. Doubtless there would have been hundreds, if not thousands, of law officers' advices during that period.
Do you see there's an element of we don't do that except when we do? There.
No, I think the guiding principle is that adheres to legal professional privilege, that there are compelling reasons why it is in the public interest that law officers' advice remains confidential. There have been two exceptions in the last 25 years to that, so one can never say never, but I think it's an incredibly important principle to uphold.
Thank you. A few more questions, I think, around this subject. We'll start with Pam Cox.
Thank you, and thank you for coming in today. How would you both define the rule of law for the general public, for our constituents?
I think that is an incredibly important question that we are grappling with. So I've spent a large chunk of my career in lectures and seminars in wood-panelled rooms talking about the rule of law and debating the rule of law. And I really enjoy that. But I think the challenge of the age is to get those discussions out of university halls and inns of courts and into classrooms and into youth clubs, and to identify the language and the explanation that we give to people as to what rule of law is and how it works for all of us in an completely apolitical way, and so that we all have an understanding of our rule of law heritage. We all have an understanding of what it is and what it means to all of us, and we can then all work together to jealously protect it. And I think the task of identifying how we explain it is as complex as it is important. It is something that, together with the Lord Chancellor, we're thinking about deeply, about how we use it and where we use it and how we deploy it, and how we do that in a way that builds consensus, that it's not a party political issue in any sense, but it's talking about rule of law and how it applies to all of us. Now, I can give you an example. If I go in, I've talked about rule of law, as I say, for years, and I've gone into schools for years as a lawyer to talk about rule of law and what it means with organisations. One of the examples that I use is if I'm talking to kids, is to talk about football. And to kind of explain, well, we have rules in football. What happens if we take those rules away? What happens to the game? The ref. Should that ref be neutral? Or what happens if the ref favours one side more than the other? What happens if we change the rules without telling anybody? And so you just kind of use real life examples to explain profound principles about equality before law, about the importance of transparency in law, about the importance of an independent judiciary. And you can do that in a really non-patronising way that communicates really core values in really understandable terms. And I think there is a project for all of us across parties to be thinking about how we explain those principles in a way that people realise that they belong to us all and they're important to us all.
Would you support the revising of the wording of the oath that you take in this position to make the rule of law more accessible as a term? There's been some discussion of revising the relevant oaths that you take on this.
Well, I did revise the oath with the permission of the Lady Chief Justice and the Lord Chancellor when I was sworn in as Attorney General, to include for the first time, I think in about 600 and something years, an express reference to the rule of law and the duties of the Attorney General and the Solicitor General. I mean, I'm not sure. I mean, that is a long and complicated oath. I'm not sure that necessarily our kind of desire to get rule of law out there in a way that everybody understands is necessarily going to be met by changing the oath that I give in the Royal Courts of Justice. But the underlying point about the need to explain rule of law, about the need to explain fundamental rights in language that everybody understands, I think we see this as part of our mission together with the Lord Chancellor and indeed internationally with the Foreign Secretary.
So, for example, how might that manifest itself in terms of dealing with contentious issues like immigration and terrorism? How might we see a different approach or different language around this?
Well, could I separate out two things that are going on there? So there is firstly the kind of general outreach that we want to do as a government on what the rule of law is, explaining what the rule of law is, why it's important, what rights are, why they are important to all of us. Separate that out for how, as a government, we're going to approach all the various challenges that we face. And the Prime Minister has made really clear that we're going to be a rule of law government. We're going to do that through a rule of law framework. We face multiple challenges. As a government, we're determined to face them. They're going to require, of course, as the Prime Minister and lots of my colleagues have explained, they're going to require some radical rethinking across vast areas of government about how we do things to meet the challenges of our generation, but they will be ones that we will do in accordance with the law.
And how would you suggest, this is the last one for me, how would you suggest that we as a committee assess your success in doing this in 5 years' time, in terms of upholding, strengthening the rule of law?
Well, I think there are going to be a range of metrics that you can apply. Not least one will be the quality of the legislation that we pass, the policies that we implement, the language that we use. I think those will all be metrics that in 5 years' time you can apply to seeing whether or not deeds have matched the rhetoric.
Thank you very much. Thank you, Chair.
You're right.
Thank you, Chair. I'm just going to ask a slight follow-on from what you were saying earlier, actually, Attorney General and Solicitor General, just in terms of the context we now find ourselves in, new government, 6 or so months in, the rule of law is very much stamped all over it for the reasons you outlined, and obviously in the context of the comprehensive spending review that is circling, I'm just wondering what, from your respective external experiences, private practice now coming in into the roles you now hold, your views on the sort of efficiency and quality of the external legal counsel that you use and the panels that service you and that service obviously the wider government, and whether or not you think that they're giving the value for money and the quality that you and the wider government needs, or whether in the context of, as I said, rule of law, new government and the CSR, you feel that there is a need to review that.
So, the first thing to say is I think that in respect of external legal services, and I should say also internally, I've come in and been very impressed by the standards. But as with all aspects of our work and all aspects of government work, in the early days, we are also, it's kind of coin of phrase, kicking the tyres. Trying to assess whether there is room for improvement or a need for change. And that's a process that's ongoing. We're looking at that across a number of metrics. We're looking at that in terms of value for money. We're looking for that in terms of standards. We're looking at that also in terms of equality and representation of the people that we instruct across government. So that's all, I mean, it's still early days, but those are all projects and processes in motion.
Thank you. And I want to sort of go back as well, pivot to your Bingham Centre speech in October last year, where you emphasised the relationship between the rule of law and democracy and highlighting the risks and the threat associated with populism. And so you've used some practical examples and talking about the football example in schools to help visualise, but I'm wondering, maybe it'll be football, maybe it'll be something else, but just in practical terms, how can upholding the rule of law meet that risk to democracy, which is obviously not just faced here, it's faced across the world, both by the risk of populism, but just sort of widespread misinformation? Yeah,
I mean, the question raises one of the kind of most profound challenges of our age. And I'm not going to be able to give you, in the space of a kind of 2-minute answer, the full panoply of measures that governments here and allies across the world are going to need to be thinking about. But to return to what I said before, it's not enough for us as a government to be simply applying the rule of law to the decisions that we make, although of course that is essential that we do so. There is, I think, an important moment for governments to be out explaining the importance of the rule of law to everyone in language that we all understand. And again, I really want to stress that is not a political motivation. Governments of all colours in this country for generations have talked about the importance of the rule of law. I think now is the moment in which we need to be explaining that importance more than ever before, in language that people understand and recognise, and in places that sometimes people don't go and talk to people about rule of law and fundamental rights. I think that is an enormous challenge for us as government.
If you want to add anything else, Solicitor General.
Well, I'd only add to what the Attorney General says that clearly I think a response to populism is a clear cross-government issue, and an issue not just for us but governments in other countries as well. But I would very much agree and echo what the Attorney General says about embedding the rule of law. And to come back to Pam, your question, for me the rule of law really is about the equal application of the law. And as the Attorney General says, we're used to talking about this concept and hearing about this concept in the kind of legislative and judicial sphere. The reality is that the rule of law underpins British values. It's who we are as a country. It underpins our prosperity, our security, our safety. It's how we do business. This is really, really fundamental. And as the Attorney General says, I think the more we can do to make sure it's understood as such, the better, and indeed the more resilient our democratic institutions will be.
Could I just, you may have seen this, but there was a study that was published yesterday by a communications consultancy, FGS, and they had a number of findings. Can I just give you two, just to kind of tell you what's on our minds? So 24% of the UK electorate, according to this poll, believe that voting doesn't make a difference. And more than 1 in 5 people under the age of 45 agree with the statement that the best system for running a country effectively is a strong leader who doesn't bother with elections. Now that is a rule of law challenge for all of us.
Thank
you. Sarah.
Hello. Thank you for coming. Can you please talk to us about the practical impact of your amendments to the Attorney General's legal risk guidance?
Yes, of course. So let me just explain because not everybody might know what the legal risk guidance is. So this is a document that sets out to all government lawyers and external lawyers how they should describe legal risk when they are advising ministers or officials or any other decision makers. And it sets out, in order to ensure consistency, ways in which legal risk should be described. And it's been amended a few times in the past by Attorney Generals. I came in and took the view that the version that I was presented with needed to be updated. It needed to be updated for a number of reasons. Firstly, I wanted to give, in the early days, a very clear message to all those advising government and all those who receive advice of the importance and the centrality of law to what government does and the importance of rule of law to what government does. So I took that as an opportunity. I also had a concern about the version that was in force at the time, because my concern was that rather than trying to ensure that legal standards were maintained, it risked diluting legal standards. And let me explain why that was. It led to what I thought was an unfortunate risk of ministers being advised that there was a respectable legal argument for policy A. What decision makers weren't told is that what a respectable legal argument meant was that it was highly likely to be unlawful, but that if you advanced it in court, you wouldn't be struck off for advancing such a poor argument. Now, it struck me that that could never become the default position for law in government. And that is why I revised the guidelines to make sure that we were using the framework so that ministers were always best advised as to what the real risks were, so that decisions were taken with a proper legal analysis that flagged up legal risk in a way that would be clear to the decision maker. So that was the motivation behind the changes.
Thank you. I have some concerns that the previous government, for instance, when they tried to change food regulation, for instance, received commercial litigation from Kellogg's, which they won. But there is a chilling effect potentially when government tries to take on commercial interests, that there is concern about the potential litigation risk, and that can have an influence on what ministers are prepared to do in the first place. I wondered what your attitude is towards that, and also whether you feel there is a role for differentiating between level of risk around, for instance, international law, which I personally think we should be highly compliant and very careful about, and level of risk around upsetting commercial interests. And one of the reasons I ask this is that it's very clear that, for instance, the changes that the government is interested in making on leasehold, which will be very much in the best interests of many of my constituents who are having a great deal of trouble, are definitely going to have a commercial impact on companies, and they are very likely to consider litigation in that context.
Yes, so I mean, obviously, forgive me if I don't comment on any particular bits of legislation. It's important to stress that decisions will not be decisions of law officers or lawyers. So the decisions will always be those of ministers, and our role as lawyers is to help tool up decision makers to ensure that they have all relevant information and that the legal analysis is at the centre of that. But ultimately, they will make the call on those decisions. It will include, and any good legal advice will include, a risk analysis. Okay, what happens if you take this litigation? What are all the risks that you would face? In the same way I have spent 30 years advising clients outside of government. You would look at a case, you would assess what the legal merits are, you would try and work out what happens if you lose, what are the downsides, what are the costs, what are the implications. And that's what good lawyers in government do day in, day out when they're advising. I don't think government is going to be cowed in doing the right thing by fear of facing well-resourced litigants in court. If we are confident in our policies, having decided these are policies we want to take, if we are confident in their legality or comfortable with the degree of legal risk, the mere fact that it's a well-resourced defendant on the other side is not going to stop government, I imagine, in moving forward.
Thank you, Chair. Just a very quick supplementary to what you were saying to my colleague. Just in terms of the guidance you said that you effectively inherited, and you were concerned that effectively it was saying the standard of advice that should be presented was just enough to avoid getting struck off, but could be unlawful nonetheless.
Yes.
Can I just be clear, when was that guidance revised, and who was the Attorney General at the time?
Forgive me, I'm afraid it's gone through several revisions over time, and the precise point in which that phraseology entered the document is not at the tip of my fingertips. Can I come back and write to you with the...
I'll be absolutely fine.
Yeah.
Thank you, Chair.
Can I just add one question to that, which is, are you saying or not that there are risks in caution as there are in risks in obscuring dangers that might follow? In other words, the example of leasehold was given. One could look at the government's very ambitious targets on house building and planning and things of that kind. If you want to be a radical and reforming government, is your guidance on legal risk going to impair that in any way? And you mentioned well-resourced opponents in court. I will come on to talk about the SFO later on, but I think a lot of people would see that the SFO has exactly suffered from that. It has been cowed by trying to prosecute very well-resourced litigants.
The guidance will not inhibit decision makers. The guidance will ensure that decision makers are possessed with proper, full, comprehensive legal analysis on which to make their decisions. I don't think my colleagues in government are likely, when it comes to those decisions, to feel when they are trying to drive forward our ambitious programme of change, will feel cowed at the prospects of facing deep pockets defendants in litigation. That, I imagine, is not going to be a factor that bears heavy on decision makers as we drive through change.
Chair, if I might add to that, I'd just say that I think the changes to legal risk guidance don't in and of themselves obviously make any particular policy. You mentioned one, there have been mentions of others. They don't in and of themselves make a particular policy more risky. It's obviously entirely right that ministers are properly advised on risk, but to come back to the point that the Attorney General was making earlier, our advice is solutions focused, because there's an enabling of the reform that the country so badly needs to see. And I think it's right that it's possible to be both an agent of the rule of law and be offering robust solutions-focused advice that helps ministers get to where they need to be with clear policy solutions that are legally robust.
Thank you. Well, change tack a little. Brenda just.
Thank you, Lord Hermer. I've listened to what you've said with a lot of interest, actually. And you mentioned that 22% of voters don't actually think voting makes a difference. I believe that some of that must be due to the fact that sometimes they feel they don't get straight answers from politicians. There are issues that arise that constituents have a lot of concern about, and they look to their MPs to give them answers. One of those issues is what's happening in Gaza at the moment. And we know that there's an arrest warrant out for the Israeli Prime Minister issued by the International Criminal Court. One of the answers that my constituents would want to know is, would that arrest warrant be enforced if the Israeli Prime Minister visited this country?
So let me start by saying I completely share your view that when people don't feel they're getting straight answers from politicians, it does nothing to foster belief in our system. It undermines our system. I'm, however, not going to give you a clear answer to your question, and that's for two reasons. But I want to give you a clear explanation as to why I'm not giving you a detailed answer. The first reason is because of the Law Officers Convention, which I've explained before. So I can't get into details about matters. The second is because, as we have explained, the question of the enforceability of an arrest warrant for anybody is going to be dealt with by a domestic statute, the International Criminal Court Act, that places the decision as to whether or not a warrant should be executed and given effect to, and what the relationship with any immunities might be. That is a question that Parliament has decided to give to the courts. And I think it would be inappropriate to, as attorney, to give a public statement as to where I think the courts may go or should go. Because I think it's essential that we steer clear of the court's lane on that. What the Foreign Secretary and others have been clear about is our support generally for the work, the importance of the institution of the International Criminal Court, and indeed as part of our commitment to the international legal order generally. So I'm really sorry not to be able to give you a straight answer to what was a straight question, but there's a reason, which I hope I've explained, why I can't.
Thank you. I've got a couple of further questions,
Of course.
and I probably can anticipate the answer that you will give, but I'll ask the questions anyway.
Of course.
So, because of the seriousness of the issue, I imagine that you've had some discussions with the government about the legalities of executing such a warrant.
Well, again, I'm sorry, but I really hope I've explained the rationale as to why the Law Officers Convention is in place. It's a really good rationale, but it can be frustrating when people are asking perfectly reasonable questions. But I'm afraid I hope there's a perfectly reasonable answer as to why I can't indicate whether I've been asked to advise or not.
And I suppose your answer to the question whether we've had any discussions with other countries would be the same. On the, I mean, it as I say, it is frustrating. I have to say that, because when constituents ask these questions to us, and
of course,
they realise that their MP is on the Justice Select Committee, they will be looking to me to get answers for them.
Of course.
And so it is something that a lot of concern to constituents. And I do, as a lawyer, I do appreciate the need to have confidentiality, and I do appreciate the Law Officers Convention. But I think sometimes as MPs we bang our heads against the wall because we can't get the answers that we need to give to constituents, which are really very reasonable questions that constituents ask of us.
They're perfectly reasonable questions, of course, and it's on an issue that people feel passionately about. There are, of course, lots of other avenues, not least my colleagues in the FCDO who answer before Parliament and seek to explain the position. In respect to the ICC, obviously, it's a bit more sensitive because of the judicial nature of the process. But it would be a bit like if you were advising somebody back in the day, and a local newspaper. I'm not seeking to compare this committee to a local newspaper. This is just an example. Had asked you, has your client approached you to talk about this issue? And if so, what did you say to your client about it? You would say, I can't comment. Now, I'm afraid for us to be able to do our jobs really effectively as law officers, the convention exists. And I can say from personal experience, working under the umbrella of that convention, it does assist in the work that we're able to do. Would harm it were it not for that convention. So I'm sorry I can't answer your question, but I can't.
Well, as the editor of the local newspaper, let me try and perhaps it is a little frustrating, but we understand where you're coming from, and maybe I can ask about legal process rather than legal advice. So we had, for example, a urgent question earlier in the chamber this week from the former Deputy Foreign Secretary about the situation in Sudan, based on the US having determined that genocide was happening there. And it really is a sort of process question about there would be an expectation if our closest ally, in a country which frankly doesn't trespass into international law, thinks that is something that should be called out in that way, where we are in that process and how we could get to such a determination.
Yes, again, and I'm sorry if it's going to cause some frustration, but I think those are questions really for the FCDO, certainly in the first instance, to answer.
Well, the problem there is, I think, the one I alluded to earlier, which is that was asked by a number of members to the FCO ministers in the chamber, and although very laudable answers in relation to humanitarian aid and to condemning what was happening, very little to address those specific questions on the determination of genocide.
Can I answer that kind of question then in a more abstract way? It shouldn't be taken as relating to any advice that is going on in respect of any particular country. But it is obviously compliance with international law also requires calling out any country where we think there have been breaches of international law. That's kind of essential as part of our understanding and the role we play within the international legal order. Some breaches of some conventions have very profound legal significance. They require third-party states to take certain steps. They place obligations on third-party steps. So you would expect, in respect of those conventions, for very serious thought to be given by, amongst others, lawyers. And we are blessed in this country by a absolutely first-class legal team within the FCDO of brilliant international lawyers. I mean, some of the finest international lawyers internationally sit within the FCDO. You would expect detailed consideration to be given to those legal standards, applying what we know about the situation in country A, B, C or D, and then detailed thought to be given by policymakers looking at that legal advice as to whether or not there has been a breach of a given convention, and if so, what the appropriate response of the United Kingdom will be. So as a matter of generality, these are things that are taken incredibly seriously by government. But as to a particular country or a particular conflict at a given moment, I don't think I can say any more than that.
Well, on another, if you like, process matter, we had the advisory opinion from the ICJ last July, I think, and the government responded immediately by saying it would give serious consideration and would respond. Are we any nearer to getting that response?
Well, I can tell you that, as you would expect, when the apex court in the international legal order gives an advisory opinion, that is something that the government is obliged to consider in detail. The particular advisory opinion here is of potentially wide-reaching impact because it requires, on its face, governments to look at all different aspects of governmental life. You would not expect that to be done in an over-hurried way. So, as I understand it, steps are being taken to consider it in detail. I can't give you, I'm afraid, a date in which that process will be completed.
Months, years? Do we know any?
I very much doubt it's going to be measured in years.
I think we'll move on from there. Yes, because I know some members have other engagements, I'll call Josh Babarindi to ask these questions now.
Thank you. My question is about violence against women and girls. The government has announced, a very powerful aspiration to halve it over the next decade. And my question is about the measurement of that. So I put in a written question to the MOJ on this, and I asked, relatedly, how many domestic abusers are in prison at the moment? What is their reoffending rate? I didn't ask things like, what is the conviction rate, etc., but I could have done. And the response that I got started with this. It's not possible to robustly calculate the number of domestic abusers in prison or their reoffending rate. This is because these crimes are recorded under the specific offences for which they are prosecuted, such as intentional strangulation or suffocation. And this seems to me to be really problematic. How can we possibly track an aspiration to halve violence against women and girls if we're not able to track how many domestic abusers there are, what their reoffending rate is, and I assume what their conviction rate, etc. is? I've sought to put forward a proposal to try to address that gap that I've spoken to the Solicitor General about, to create a specific offence of domestic abuse in the law, so that we can better record these crimes and better track them, and many other things. And I'd be interested to understand what your reflections are on what clearly seems like a gap there, and if the government isn't going to pursue something like I'm suggesting, how is it going to better track this critical element of reducing violence against women and girls?
Thanks, Josh. Lucy and I have kind of slightly divided up topics, so
I'm happy to answer this one, Josh. I mean, and obviously, as you say, it's an issue I know that you're doing an awful lot of campaigning on. I know that you have a background and experience in all of these issues, which you've brought to Parliament, which is obviously absolutely fantastic. I know, as I said, you're speaking out on these. Clearly right that domestic abuse covers a whole range of offences, and those specific offences in law, as you say, it's a gamut of things. So there's the stalking and harassment, RASO offences, but then also things like forced marriage and FGM, things like that as well. And as you know, so when it covers a range of offences like that, domestic abuse is an aggravating factor when it comes to the sentencing. Exactly. I take the point you're making on tracking. You're right to refer to the mission to halve violence against women and girls in a decade. That's an integral part of our Safer Streets mission. And another part of that, as you know, is to restore confidence in the criminal justice system. And the Attorney General and I superintend the CPS, and the CPS have a really integral role to play in that Safer Streets mission. They're doing a range of things to help tackle domestic abuse, particularly RASO offences, as indeed are the government. And the CPS have metrics wherein they can track what they're doing, their work, to help us understand where they are vis-a-vis our priorities, which, as you rightly say, halve VOG within a decade, and the CPS's priorities, which match those.
And so do you think that the kind of infrastructure of offences as it currently stands, and the recording infrastructure, is sufficient to help with that measurement process?
I think one of the things that better understanding how the CPS work, one of the issues, and in fact I think the DPP made reference to this himself when he was giving evidence to your committee, is we need better data when it comes to the criminal justice system across the board, not just the CPS. And we also need, the CPS need better technology. And that was one of the things that I know, as I said, the DPP is very concerned to push forward within the CPS. As you know, with data sets, it's really important that data sets talk to one another and they don't just exist in silos, and fundamentally that they can lead to better policy making. I mean, that is the point, and from the CPS's point of view, to be able to better track what's happening.
I'll leave it there. Thank you so much.
Thank you very much. Is everyone?
I've got to run, by the way, but I really appreciate your time, and thank you.
We're always willing,
Thanks for your
happy
questions.
to indulge. I'm going to get back onto the, and come back to this in a second, if that's okay. I'm sorry, Neil, you were to be called next, so thank you for bearing with us.
No, thank you very much, Chair, and good morning to you both. Can we turn to the issue of the accountability of war crimes in Ukraine? And specifically starting with the crime of aggression in Ukraine, of which the International Criminal Court doesn't have jurisdiction because neither Russia nor Ukraine are parties to the Rome Statute. However, a number of politicians and experts in the field have signed a combined statement and declaration calling for a special tribunal to deal with a specific international law crime. The Ukrainian people are in support of having a special tribunal. President Zelensky has indicated his support and called for it. And critically, in the absence of it, the deaths of young Ukrainian soldiers can't be prosecuted effectively. In light of this, are you able to set out what the delay has been in setting up such a tribunal?
Well, I mean, thank you for the question. I mean, it's obviously an incredibly important issue. The United Kingdom has been integral to discussions. There's a core group that operates working towards the creation of a tribunal for the crime of aggression. We've played a leading role in that. There are regular meetings trying to forge consensus as to what the scope of the tribunal should be and the details about the tribunal. It is never easy trying to negotiate on a multilateral basis for a court. There are kind of a range of issues in which countries will come with different perspectives, and it requires detailed discussions, detailed negotiations. There is progress. People understand the importance of moving as quickly as possible. I think we understand that this can't take for as long, for example, as the Rome process did for the creation of the International Criminal Court. We need to move quickly to secure accountability. And so we're playing our full part in trying to reach that consensus. I mean, that is, it should be said, is not the only thing that the United Kingdom is doing. I mean, we're playing an active role in training judges within Ukraine, because they obviously have their own war crimes process that's going on domestically within Ukraine, and we're seeking to support that. I have a special envoy, a former judge of the International Criminal Court, Judge Morrison, who is working hard in Ukraine to help build up a capacity to secure accountability. So can I also, at this point, also pay tribute to my predecessor as attorney, Victoria Prentice, who did an enormous amount of work on this and continues to do an enormous amount of work on this. And just to say, I share her commitment to ensuring that this country plays its full role in securing accountability for Russian aggression and Russian war crimes in this conflict.
Thank you, and I think it's commendable, the action that's been taking place domestically in Ukraine in terms of dealing with this issue. But you touched on the core group, and they met in Riga in November of last year, and at that stage a roadmap was set out. I wonder if you could perhaps give some more granular detail about that roadmap and where we are on the progress of it, potentially even a timeline for delivering it.
Well, a timeline I'm afraid I can't give you in details. I mean, there are obviously, these are detailed discussions, not all of which is in a public-facing process. I mean, all I can say, I think, at the moment is there is a real understanding of the need to move and conclude as quickly as we can. There are all sorts of issues, both of law and of practicality, that are being ironed out. Beyond that, I'm not sure there is really much more I can tell you.
And at the danger of pushing,
no,
I'll adopt the chair's approach. Are we talking months or years? Where are we in, perhaps if I put it in those terms, in the sense of a timeline?
Well, I think, again, if we're talking in terms of years, then the project, it's hard to think of a process in which the parties want to result in an international tribunal that secures meaningful accountability. It's hard to see how that aim will be achieved if we are talking in years before something is finalised.
And one of the issues, of course, that you'll be grappling with is around Troika immunity. What steps, if any, or what approach is being taken to that issue?
Well, that's a subject that is obviously the subject of kind of detailed discussion within the core group, as you would expect, and it's one on which different parties have different views, and it's an active subject of discussion. Are
you able to go into further detail about your position on that or your view on it?
I'm afraid, again, frustratingly for those asking the questions, I'm not.
It was worth a try, though, wasn't it?
Good try, Neil. But yeah,
you should have some cards to hold up.
And if we could just change tack slightly,
yeah, of course.
There's been significant investment through the ERA loan scheme, 50 billion, in terms of supporting the Ukrainian people, but that does fall a long way short of the cost of reconstruction. I think it was last estimated in $468 billion. Dollars. What considerations have been made, and any detail you're able to provide would be helpful in terms of using Russian frozen assets held in this country as a countermeasure for the reparation of the damages that have been inflicted upon the Ukrainian people.
I recognise the importance of the issue that you raise. I recognise the moment and time in which you raise those issues, but I'm afraid I cannot give you an answer to that question for the reasons that I've already explained.
I'm grateful. Thank you, Chair.
Thank you very much. Well, go back again. I'm sorry to be cutting across issues and going back to them, but we have further questions on violence against women and girls. So, Lindsay.
Yes, thank you, Chair. Yes, if I can bring it back to an area that is particularly important to me as the mission delivery champion for safer streets, but also more importantly, particularly important to my constituents in Amber Valley, and that's the mission to make our streets safer, and the ambitious target. We've already been talking about ambitious government policy, but the ambitious target to halve violence against women and girls. And I understand that one of the Attorney General's new ministerial responsibilities is to work with the Justice Secretary and the Home Secretary on this mission. And so I'd be interested to hear what work you have been doing from your perspective. We've heard from other aspects of government what they've been doing, but what you've been doing and what more we will see from you in relation to this particular mission, please.
I'm happy to address that, Lindsay, and I want to just acknowledge your background in the CPS, where no doubt you came into contact with all of these type of issues, so understanding your expertise in all of these areas. You're absolutely right. The Safer Streets mission is you're deeply familiar with, and the Attorney General and I support the delivery of the government's missions. The VORG mission, you rightly say, is within that Safer Streets mission to halve violence against women and girls within a decade. Another part of it, as I mentioned earlier, is the restoring confidence in the criminal justice system. And there are a number of things which you'll be very familiar with that the government is doing to halve violence against women and girls. Specifically, we could go through a list of them, but I heavily suspect that we don't need to, including things like DAPOs. But you asked about the Attorney General's office specifically, and as we've spoken to, the key thing that we do is to advise ministers on policy, but we also, again, as I made reference to earlier, superintend the Crown Prosecution Service, as you know, and the CPS has a huge role to play in the Safer Streets mission. So just to give you some examples, the CPS is working more closely with the police for the domestic abuse joint justice plan, also working through the victim transformation programme. The CPS is developing its strategy on violence against women and girls, as you know, paying particular attention to where we are on RASO prosecutions, and all CPS areas now are offering pre-trial meetings with victims of RASO offences, and the CPS has recently recruited 40 victim liaison officers into RASO teams. So this is really a priority for the CPS, as it is for the government.
Thank you. I actually met with the FDA last week and the Crown Prosecution Service in a joint meeting, and the FDA have recently produced a report about the CPS's role in RASO work and halving violence against women and girls. So I'd welcome the opportunity to come and see you to discuss that in more detail, because I think there's quite a lot of really useful information from within on there. So if you'd be interested in meeting with me for that purpose, that would be certainly useful for the work that I'm doing as well. Thank you. I think we're just going to ask you some more questions.
Staying on the issue of RASO cases, we've previously had discussions about the lack of prosecuting and defence counsel in RASO cases. A couple of the reasons given is that these cases are, because of their very nature, they're very distressing cases, but one of the main reasons given for lawyers not wanting to deal with such cases is insufficient remuneration. And that was following a survey done last February by the Criminal Bar Association. So would you be able to say whether you've had any discussions with the Justice Secretary about the legal aid rates that are paid to counsel? And if you haven't, is there any plan for you to have those discussions with the Justice Secretary?
I'm happy to take this one, Werinda. So you're absolutely right to highlight this as a problem across the criminal justice system. And actually, on the third day, I think, after I was appointed, I went to the Old Bailey to meet with some of the counsel who are prosecuting some of these most serious types of RASO offences, to talk to them about a range of issues across their briefs. But this was something that came up and was raised. I know also, if I might say so, from discussions with organisations in my own constituency that support victims of rape and serious sexual offences, that the shortage of counsel who do RASO work is a real problem. It leads, as I'm sure you know, to cases being adjourned and delays. It contributes to victim attrition and the slow pace of justice, which I think is, I'm sure we'd all agree, at least to some extent, is unacceptable. What barristers are paid is by way of legal aid is a matter for the Ministry of Justice more properly, but I do know that the government is committed to ensuring the long-term sustainability of the legal aid sector, as I hope that you'd expect. And I know that ministers in the Ministry of Justice have spoken previously about working with the leadership at the bar to look at the longer-term reform of criminal aid so that we can get to where we need to be. There have been, as I'm sure you're aware, increases recently to the rates that solicitors in criminal legal aid cases are paid. And I would just make one more point in relation to this, because I think it's important. I think it's critical that we have a level of parity between what defence barristers and prosecution barristers are being paid, a level of parity at least, because I think where we need to be is ensuring that we have the very best prosecution counsel, not just very good defence counsel. So there needs to be that parity. I think it's important.
Is that a spending commitment? I assume you mean that it will be levelled up rather than levelled down.
Well, I think, as I said, there's more probably matters for the legal aid agency and the Ministry of Justice. But on the broader point, Werinda, which you raise, I think I would agree, and I've heard directly that the shortage of counsel in RASO cases is a problem. And it impacts, ripples through the criminal justice system.
As you say, ultimately it's a matter for the Justice Secretary, but is that something that you would be having discussions with her about?
I mean, I haven't as yet, but as I said, I'm speaking to people and organisations in my own constituency, and I'm sure that these issues will continue to come up because, as I said, the government is committed to ensuring the sustainability of the legal aid sector.
Can I come in as well, because it ties really back to a question the chair asked me at the beginning about coming from outside of politics, and so I came with a kind of a broad awareness of some of the problems of the criminal justice system, but it's only once you get into the job that you get briefings, and some of those briefings have been haunting. And I have to say the briefing that I got in the early days about RASO and the reality on the ground for victims is one of the things that continues to haunt me. So in particular, repeated stories about victims who now wait years for a trial. On a rape trial, they are waiting years for a trial. It can be 3 years. We can all imagine what the build-up to coming to that trial is like if you are a complainant. They arrive at court, no doubt, after weeks, if not months, of worry, sleepless nights, to arrive at a court, go past a few buckets that are picking up the rain from a leaking roof, to be told, I'm really sorry, we don't have prosecuting counsel, your case isn't going to happen today. And I'm also really concerned about some of the knock-on effects of that beyond the most obvious and appalling, which is what we can notice is an increase in not guilty pleas because people think they can game the system because you have victim attrition. Now that is all an appalling inheritance. And Lucy and I, this is something that is of enormous concern to us as law officers, as politicians and as citizens. And we have a role to play in our role as superintendents of the CPS to ensure that we're playing our part. We have roles in terms of being heads of the bar to ensure that the voices of those who are instructed, both in prosecution and defence, are heard in these cases. And I know this is an issue that the Lord Chancellor is determined to ensure is tackled.
Thank you for those comments, Lord Hermer, because, as you say, it is a major concern. If I can ask you a question on giving pre-recorded evidence under Section 28 of the Youth Justice and Criminal Evidence Act, obviously it has lots of benefits because complainants can give evidence outside the courtroom at a time and date that suits them, and they can give their evidence early, taking into account the delays that you've mentioned. But we did receive evidence from Professor Cheryl Thomas that said the conviction rates following trial by jury where pre-recorded evidence was given was 10% lower than other cases. Do you know how the government is responding to these findings? Is some action being taken in relation to dealing with this?
I'll take this one, Marinda. I think the statistic that you've highlighted is concerning. I mean, this is an issue more properly for the MOJ, but Section 28 is used with judicial discretion. And I think there are, and the CPS would say that there are clear and good reasons why it can be advantageous in particular circumstances to record evidence more contemporaneously. And that is all the more so when we have levels of victim attrition where they are, as the Attorney General made reference to in some of these RASO cases, going on for a tremendously long time. So the ability to capture that evidence more contemporaneously is certainly an advantage in certain cases, and I would imagine would lead to lower rates of victim attrition were it not to be used. But I think, as I said, I come back to the judicial discretion that's built into Section 28, so it has to be used with at the judge's at his discretion, his or her discretion.
Are we doing anything about the fact that the conviction rates are 10% lower with pre-recorded evidence? I mean, is there
I'd say that
any plans to, I don't know, refine the system?
Well, I think that's more properly a matter for the Ministry of Justice as to how they want to take account of that statistic.
Thank you very much. Pam?
Yes, we're moving to assisted dying, so change of tack. House recently debated the assisted dying bill, and a question that arose in and around that debate concerned the matter of legal assistance available to MPs who sponsor private members' bills. Do you think that we need a process to make legal advice more readily available in such circumstances?
I'm happy to take this one, Pam. I think I think that, as the Attorney General made reference to previously, our client in this role, in our role of law officers, is the government and ministers, so not the Kim Leadbeater in the context of this bill, or indeed any other private member's bill. I know from experience that some of those involved in the drafting of private members' bills and those supportive of them do receive legal advice and input, sometimes from barristers outside of Parliament. So I know from my own experience that legal the drafting can be fed in that context. But in relation to assisted dying specifically, the government has a responsibility, and actually this would apply to any private member's bill, a responsibility to make sure that legislation that passes through Parliament is effective and enforceable. The assisted dying bill, as you know, is passed through second reading, and so the government are going to be looking at that bill and working with Kim Leadbeater to look at any amendments that might be necessary. But I think beyond that, we would go to the Law Officers Convention as to whether or not anything from us may or may not be required.
You're saying you think there's no change needed to the current arrangements?
I think it's important that in our role as law officers, our client is the government and our ministers, rather than individual members of Parliament who may or may not bring forward private members' bills. But I said, and I don't know specifically in relation to this bill whether or not there was legal input in the drafting. There may well have been, but as I said, I know from experience that there has been on others.
And I would have also thought more generally the question as to whether or not there is additional legal support for MPs is more a matter for Parliament than government.
Alan, you want to come on this, and I'll go to
Just as a very quick follow-on, and I just refer to the fact I'm on the Modernisation Committee, which is looking at a whole variety of things. And whilst the call for evidence concluded just before Christmas, I'm just wondering, in terms of kind of equanimity amongst parliamentarians, in terms of good solid law coming forwards, and all kind of predicated under the rule of law for all the reasons we've talked about in these sessions, whilst fully respecting that it may not be a remit that sits within your area for the reasons you've referred to, is there some value in whether it's that committee and whether you may contribute some written evidence in terms of how you think it may work, or whether it's Parliament or some other kind of department or non-governmental department within government, but that can support parliamentarians in sort of putting forward good quality private members' bills, because there will be a difference depending on the issue. If it's a particularly controversial one or hotly contested one, I totally agree with what you've said, Solicitor General. There probably will be inputs, and particularly if parliamentarians have good contacts, depending on what they did before they came into this place, they may be able to call on different connections, networks, in order to support them in scrutiny, preparation, drafting, but others may not, or they may not know how to access that. So do you think there's any merit in Parliament, and where that would sit, TBC, looking at something like that? Because ultimately that goes to what your job is, in order to ensure that the rule of law and good governance comes for government.
I mean, rather than commenting on any particular proposals, if I can just answer as a matter of generality, unsurprisingly, I think legal input on things is a very good idea. And as titular head of the bar, I can particularly recommend that you do so. No, look, I think there is there's quite a profoundly important point about this, that this Parliament is in the business of law, and parliamentarians from any party are going to want to ensure that the law that is passed here is of the highest standards. And so it's a matter for Parliament as to whether or not the resources available to it are sufficient. But as a matter of principle, I think parliamentarians need to have the tools necessary to discharge their obligations to ensure that the law is of the highest standards, and that they're able to scrutinise from a legal perspective laws, not least delegated legislation, through a legal lens as well as a political lens. I think there's also an important role, if I may say so, I think, for kind of legal education for us all who enter Parliament, to have an understanding of the rule of law, what the roles of the courts are, what the roles of Parliament is, vis-à-vis other parts of our written constitution. But again, those are matters for Parliament, certainly not for the law officers.
Good morning, Lord Hermer. Could you explain to me the government's rationale behind the repeal of Section 46 and 47 of the Northern Ireland Troubles Act, and whether you advised on that?
Well, Sir Ashley, I'm afraid I'm going to have to give the answer to your straightforward question, the same answer that I've given to other questions in respect of the Law Officers Convention. So for the reasons that I gave at the outset...
I'm not looking for legal advice.
I'm
looking for the political justification for it.
I understand that. But the Law Officers Convention, which is enshrined in the Ministerial Code, precludes any minister from saying whether the law officers have been asked to advise on any given issue, let alone what we have advised. I understand that the issue that you raised, if I can talk about it as a matter of generality, it is an issue that was the subject of a policy exchange paper that came out this morning. There's a parliamentary consultation process in place at the moment in respect of the proposed remedial order. And I anticipate that those who publish that paper will feed those views into that consultation process, and they will all be considered before the affirmative process that needs to go before both houses of Parliament. Sorry, that's for reasons I've given, not a direct answer to your question. Is it? Well, no, I'm afraid. Sorry, Sir Ashley. It is an answer, and it is an answer that
you
explains...
could provide a justification for the policy reasons without commenting one way or the other on whether you'd advised.
Well, I think you asked me whether or not I had advised, and I can't answer that for the reasons that I've given. The policy reasons behind that, I think, would be best explained by the Northern Ireland office, not by the law officers.
I see. You've acted for Gerry Adams in the past. Could you tell the committee whether you acted for him on any form of conditional fee agreement?
Well, I'm afraid I can't recall, and even if I could recall, I'm not sure I would feel inclined to answer a question as to how the basis on which I was paid by any given client.
Okay. Thank you, Mr. Chairman.
Thank you.
Actually, if I may on that, because there's a really important point of principle, Sir Ashley, and I'm glad you raised that. One of the concerns that I've had over the past few years about the rule of law in this country, and I've had many, but one of them has been the attacks on lawyers for doing their job and representing one client or representing another client. And I've had a concern about that from a rule of law perspective. Because one key part of our kind of rule of law framework in this country for generations has been that a legal system works best where you have advocates who are able to take on cases without fear or favour and represent clients irrespective of their own views as to what their client did, whether it was morally right or morally wrong. And that's how our system works, the rule of law. So you're right, I did represent Gerry Adams on something unconnected to the legacy. As it happens, as a reflection of our legal system, at the same time, I was representing the family of a young British soldier murdered by the IRA in the 1970s. Now, both clients understood the importance of being able to represent everybody. That's what a legal system is all about. And my concern about attacks on lawyers for doing particular cases is that it undermines faith in the legal system. And I don't want to over-egg that, but it has a particular resonance, I must say, for me, because I've been involved for many years in organisations that seek to protect lawyers working in fragile environments. And I have seen how lawyers themselves become targets, including assassinations of many people known to organisations that I've worked with and supported. And so I've seen in the most bloody terms what happens when you undermine consistently, and let me make plain, Sir Ashley, I'm not accusing you of that, when you undermine faith in integral parts of rule of law systems. So I think the idea that we have a legal system in which you have representatives, independent-minded, without fear or favour, represent people irrespective of their views, is one of the great strengths of our constitutional setup.
Chairman, if I may, as Lord Hermer has given a very lengthy reply to that, what I think undermines faith in politicians and the rule of law is whenever I want to ask a question about why does the government want to reopen the door to a wave of meritless litigation in relation to events over 50 years ago, which will result in those suspected of terrorism, like Jerry Adams, being paid compensation purely because a piece of paper was signed by Minister A and not Minister B, and yet victims of the Troubles are not compensated, and then, shall I say, you come here and you hide behind and refuse to answer questions on the merits of the case and then speak about the importance of the rule of law. And I think that's unacceptable.
Well, look, I think the Law Officers Convention is an aspect of the rule of law. I think the idea that you can, that legal professional privilege, that people can receive advice without that advice being made part made public is an important principle. And it is not as if, Sir Ashley, there are not, beyond the law officers, other ministers to whom those questions can properly be addressed. It is not as if within the parliamentary system there are not other means for you to raise that. But I think it is quite important for law officers to keep within their lane. So I understand why I understand your frustration, but I think it is misdirected at law officers. It is misdirected at law officers' question at this select committee, I say with the greatest of respect, in the circumstances in which there are many other individuals and office holders and many other forums in which those concerns can be properly raised and ventilated.
The answer to that is probably that those avenues will also be tested and tried. We did say that this session would last about 90 minutes. We're almost up to there. We have a few more questions on CPS and the SFO. Are you able to stay a little bit longer to answer those? Very good. Well, we will try and be efficient in our use of time as always. But let's go to the CPS and Lindsay Farnsworth.
Thank you, Chair. You won't be surprised to learn that I'm going to take you through the questions, some questions relating to the Crown Prosecution Service and your superintendence of that. The first thing I wanted to ask about is the framework agreement between the law officers and the Director of Public Prosecutions, because my understanding is that that should really be reviewed and revised every 3 years, but also following a change of Attorney General and a change of the Director. And the Director who gave evidence, Stephen Parkinson, to us already, I think took up post in November 2023. The last time the framework was updated was 2020, and I think that that there's been 4 different Attorney Generals since then as well. So do you think the framework requires revision now? And if so, how would you amend it as it stands at present?
So thanks, and it's no surprise you're asking the questions about the CPS. The framework agreement is a very important public-facing document because it explains several, but 2 in particular, key dynamics. The first is the operational independence of the Crown Prosecution Service, which is a kind of a democratic principle that they are able to conduct their work without interference from politicians. The second is that politicians do have a role in respect of strategy and policy insofar as that does not impact upon operational decision making. And I think it is entirely appropriate that there is an outward-facing framework agreement that codifies that in the looser sense of codification, and also is public and explains that, because there's also an educational role, I think, as well as the kind of binding role between the CPS and the law officers. It's also important we get it right. I didn't want to revise that in the early days in office because I wanted to kind of get a real-time understanding of the work of the CPS. I wanted to get a real understanding of the interactions between the Law Officers Department and the CPS. I think it's something we're going to need to conclude, but I'm also mindful that Lucy has only been in post really in recent times, and I think it's really important that as law officers together we pool our shared experience and work that into our analysis of the existing framework agreement, the extent to which it needs to be changed, and if it's changed, what those changes are.
So do you have a timescale in mind for when you would like that framework to be available to the public?
Yes, I would hope within the next few months.
Great. Thank you. That's useful, thank you. Moving on to one of our favourite topics on this committee, which is the backlog of cases in the Crown, in the courts, particularly in the Crown Court. I can attest to the fact that the Crown Prosecution Service would collapse if it wasn't for the goodwill and commitment of its staff. And that has been the case for many, many years now, but never so keenly felt by the staff, I think, than at the present time with the current state of the backlog in the Crown Court. And the director gave evidence to say that he expected the number of new cases to increase by 10% next year, which I can tell you the staff will be very concerned about in terms of capacity within the service. So yes, the budget was increased in the October budget. Do you think that the Crown Prosecution Service have the budget that it needs, given that background that I've outlined?
I'm so sorry, Lucy.
Well, I'm happy to take at least a portion of that, Lindsay. I mean, obviously right to refer to the vital role that the CPS have to play in the criminal justice system as a whole, and indeed in the Safer Streets mission. We were successful in securing a robust settlement in the first round of the spending, an additional £49 million, and clearly it's up to the CPS how exactly they spend it, but we've talked earlier about some of the things, some of the priorities for the CPS. So we would expect that they would be, and I'm sure actually the DPP may have made reference to this in his evidence to the committee, hiring additional prosecutors, putting particular emphasis on RASO work, and in particular I know actually that he referred to the support that the CPS are giving to victims. I think it's really important alongside that, and indeed this is something the DPP talked about as well, that there is a real drive within the CPS for efficiency. I know that that's something that the CPS is paying particular attention to, and one area within that I know the DPP thinks is particularly important is tech. The use of technology, and I think we're going to, the Attorney General and I, clearly be working really closely with colleagues as part of the second round of the spending review to try and ensure that we can secure the best possible settlement for the CPS to enable them to play the best possible role that they can, which, as we've said, goes to restoring confidence rather in the criminal justice system as a whole.
I was just going to take the opportunity of your question, Lindsay, just to pay credit to the extraordinary work that those in the CPS do. I mean, one of the pleasures of this job is that you go out to CPS offices. I mean, not least for me, I will always remember going to CPS Merseyside in the months following the Southport murders and Southport attack and the riots, and talking to the extraordinarily dedicated staff there, talking through what they need to face in their everyday working days. And I know that's mirrored throughout the country. We're going to Cardiff on Friday to see the CPS in Cardiff, and it's always a real privilege to meet people from the CPS, listen to what they're doing, of course try and understand the difficult conditions in which they're working and do whatever we can to improve things. But we are so lucky in this country to have the hard-working lawyers and support staff within the CPS.
Moving on to back to fees, really. When the Director of Public Prosecutions gave his evidence to the committee, he made some comments about defence fees, defence barristers, and the current fee structure, and how that is set up and may well lead to late guilty pleas because the fee structure is such that that is an attractive way of doing business, if you like. And I think that's led to some concern from criminal defence barristers about the accusation or intimation that that is a deliberate ploy on their part. So do you think that there is a problem with cases and guilty pleas being delayed because of the fee structure, deliberate or otherwise? And please do comment if you think there is any deliberate delaying happening. And have you spoken to the DPP about his thoughts on that?
So, Lindsay, I'm happy to take this attention. I have spoken to the DPP about it, only very briefly. And my understanding of where he was going with those remarks to the committee, were, as you say, to focus on the early guilty plea issue and the differential in fees. And I think the DPP would say this is one of his priorities, to increase the number of early guilty pleas. And to do that, it's important to get the defence to engage with the CPS file as early as possible. I mean, I don't have all the detail, and clearly changes to the rates, as we were saying earlier, is more probably a matter for the Legal Aid Agency and the Ministry of Justice. But what I do think is important is that the DPP is, and he said this to your committee chair, the issues in the criminal justice system are really significant, both upstream and downstream of the CPS. And the DPP is very much of the mindset that we can't just keep doing the same things over and over again and expect different outcomes. So without prejudice to this specific issue, I think we would both be supportive of the DPP thinking about potential solutions which may bring about positive changes, and indeed, the potential to explore those if they can help do things differently and solve some of the, as I said, significant issues that unfortunately we've inherited in the criminal justice system.
Did you receive any complaints about the director's comments into your office? Or?
I haven't. No, I haven't.
I have. I take the general point you're making, but the question was a very specific one about comments there. And criminal defence barristers might well say that early pleas would be possible if the CPS was able to provide more of the case earlier, so that clients could be advised on the basis of plea. But on that very specific question, that there may be some, obviously not all, some criminal defence barristers who will game the system, for want of a better word. Is there a government view on that?
I don't think there's a government view on that, but can I just say this? I mean, we obviously have an important but limited role in respect of our superintendents in the running of the criminal justice system. What we, and I say we firstly as law officers, but then part of this new government, are absolutely determined to do in this area, as in so many other areas of government, is try and understand problems. Not deal with them in a knee-jerk way, but to lift up the bonnet, try and identify all the different parts, try and work out what is not working right, and then solve it. And you've got examples of that in the criminal justice system. You can see what the Lord Chancellor has already done with her reviews headed by Sir Brian Levison, with a review by Dave on criminal justice system, with a review headed by David Gauke on sentencing. We are determined to lean into complexity where that is necessary to understand how to change systems in this country for the better. So we are not going to shy away from problems. We're not going to shy away from calling out problems when they are problems, whoever's caused those problems, and we are determined to fix them for the long term, not for the short term, for the long term. And so this is, in some sense, emblematic of that. If there is a problem, we're going to explore it, we're going to understand it, we will call it out, and most importantly of all, we are going to fix it in an intelligent and systematic way. That's what we are about.
You've finished. Just finally then, just a couple of questions in relation to the Serious Fraud Office. I mean, there certainly has been a perception, I'm not necessarily talking about under the current director who's only been in post a year, that the SFO has lost its way in terms of, well, a large number of high-profile cases that collapsed or withdrawn, some of the conduct within the SFO, and indeed the NRC case, and what looked certainly to sort of informed outside observers as the chaser being chased, as it were, on those cases, and that's of concern. It's concern of performance, but a lot of this seems to be related to funding and the inequality of arms, as it were, between the SFO, and it's extraordinary that a government agency should be in that position against a defendant. Are you concerned? Because what appears to be happening now is that the SFO is changing its brief, and it's now going after small and medium-sized fish because that's what its resources allow it to do, and letting the big fish off the hook.
I'm happy to take that, Chair. I mean, the SFO obviously prosecutes the most serious cases of fraud and bribery and corruption. And since 2020, so in the last 4 years alone, the SFO has brought over £1 billion into the Treasury from penalties. So it does play an incredibly important role. But I think it's right to refer to the cases that the SFO conducts as they are the most complex. They're very often multi-jurisdictional cases, and the challenges that arise, and I know some of this from being a commercial litigator myself, that arise in those kind of cases, they are frankly challenging cases to run. And clearly when the SFO's running cases about fraud and bribery, complex fraud and corruption, they inevitably are incredibly complex cases. But it's right, I think, some of your comments there, Chair, you were alluding almost, I think, to some of the recent cases that the SFO has been involved with. And we know some of the challenges that have arisen in those have related to disclosure. And that's why we've paid particular attention, and will continue to do so, that the challenges that the SFO faces in that area, to ensure that they are properly resourced. So when I met with the director quite recently, we were talking quite a bit about the technology which the SFO is starting to use for disclosure. And these are, as I said, extremely complex cases where the disclosure exercise will involve sort of in excess of 40 million documents. So the ability to use technology, and particularly technology-assisted review, to run an algorithm over documents, to be able to serve up what might be the most relevant documents for review first, those kind of things can really, really assist the SFO, and indeed others that use that kind of technology, in speeding up what would otherwise be extraordinarily complex disclosure exercises.
Indeed.
Sorry, as a former prosecutor, disclosure always triggers some feelings
triggering
because you're absolutely right.
Understood.
I worked in the CPS in the complex casework unit and the organised crime division in my time, which have big cases where the disclosure, so the unused material that isn't part of the evidence but does have to be reviewed for disclosure to the defence in whether test is met, can run into thousands and thousands and thousands of pages. And so I do share the pain of the Serious Fraud Office in that regard, and AI may well be a useful tool, but what protections are there, or what safeguards are there? Because if we're going to be using technology, because there are aspects of disclosure where it's a judgment call as to whether the test is met. So is it reasonably capable of undermining the prosecution case? Is it reasonably capable of assisting the defence case? Is the test? And that is quite a subjective judgment call. So if AI is going to be used, has that judgment call been factored into it? Are you aware of the work to consider that?
I'm sorry for triggering those horrible disclosure-related memories. I have some myself, so I know entirely what that's like. I mean, it's obviously really, really important that the technology which is being trialled and which may well be implemented and expanded elsewhere is used in the right way, and indeed from the SFO's point of view it would all be done within, as you referred to, the disclosure guidelines. So clearly that's incredibly important. You'll know there's also been the HMCPSI report since the G4S case, which I think was in May 2023, and the recommendations stemming from HMCPSI's report are in the process, I believe, of being implemented, and we're also expecting the report from Jonathan Fisher's review in relation to disclosure as well.
Thank you.
That report suggests there needs to be a long-term funding strategy for the SFO, and isn't that what's lacking here? That it doesn't have the resources. It raises a lot of money through successful cases, but that money is not necessarily put back into prosecution of fraud, which might then generate, well, not only resolve serious criminal matters, but it might then generate more funds of its own. Isn't there a fundamental problem with the way that the SFO works at the moment?
I think in relation to the report on disclosure, my understanding is that that's with the Home Secretary. So clearly, when it comes to the AGO, we'll review it and all those the recommendations in detail. Clearly important that we do that. But I think on your wider point, Chair, there is and has been in the past an inequality of arms point for the SFO vis-a-vis some of the solicitors and barristers are on the other side, and the well-resourced nature. And I think the Attorney and I would obviously would be supportive of the SFO in any discussions that it wants to have around more funding for the use of technology, and indeed that goes to disclosure. But in our superintendent's role, I think it's important that we have all of that oversight and clearly
are you actively
making
lobbying
the
for that
best.
now? Are you actively lobbying for effectively a beefed up SFO?
Well, we'll be having discussions with colleagues in the same way that we will about the CPS, about the funding arrangement, the funding envelope. And as we've referred to, I think both organisations play an incredibly important role in slightly different ways.
Okay, I'm not seeing any other indications, so on that I will bring the session to a close. Can I just thank you very much for your time, particularly for overstaying, and I hope that it's been some benefit to you, as it certainly has to us. And on that note, if I may, I will close the meeting. Order.